I would put his submissions, my lord, in 3 silos. One on law, second, my lord, on facts, the third, my lord, rhetoric with some sarcasm. Insofar as the third is concerned, my lord, I don't think I need to spend my time.
What is the third?
Rhetoric with sarcasm.
Sarcasm.
Yes.
Right.
And so far the third is concerned, my lord,
All right.
I will not detain your lordships because I do not think it is appropriate for us to do that. Though, my lord, I can
Lot of
reply to that.
rhetoric has happened.
My lord,
Lot of rhetoric has
that's what I'm saying, my lord. A lot of rhetoric has happened, though I can reply to it, my lord, in the same manner, but I will not.
No,
waste
it's
all
all-
time. Now, my lord, coming to the, I would first address your lordships on the question of law, my lord, which I want to place before your lordships a slightly different perspective, so that, my lord, your lordships will define the contours of interference in a judicial review proceeding with respect to an action purportedly taken under Section 17A. Kindly now see Section 17A for a minute, my lord, in the perspective in which I want to place it before your lordship. I know it has been read to your lordships ad nauseum, but let me place it in the manner in which
Yes.
I would like your lordships to kindly read.
Yes.
No police officer shall conduct any inquiry or investigation into any offense alleged to have been committed by a public servant under this act, where the alleged offense is relatable. Your lordships may mark that word, my lord. There is something that turns on this word. Where the alleged offense is relatable to any recommendation made or decision taken by such public servant in the discharge of his official functions or duty without prior approval. So, my lord, this section does not contemplate even an application. Please contrast this with Section 19, my lord.
No, sanction operates on a different footing.
No, there, my lord, under 19, it contemplates a request.
Yes.
17A doesn't even contemplate a request.
It's all right. We'll see.
No, my lord, what was told to your lordship was that it is only the police officer who can go and seek
So
for...
that, if you see, that I straight away dispelled.
Yes.
For the reason that no police officer can begin investigation unless there is an approval. That doesn't mean police officer only should seek approval.
Exactly.
That I
And
already
in fact,
said.
my lord, the question of seeking approval itself is not contemplated under 17A. It is permissible that the authority acts on information which is available in public domain or otherwise without even a request being made. This becomes material, my lord, in the context of the serious submission that was made before your lordship, that a copy of the petition that had been submitted by respondent number 4 was not furnished to the petitioner, and that is a grave infringement of the mandatory requirement of 17A.
If the foundation itself does not require,
Exactly.
why would a superstructure require?
Exactly. That's what I wanted to point out, your
All
lordship.
right, next.
Therefore, that's first subject. Then, my lord, the second question would arise in the context of 17A. Should the recommendation be made or a decision to be taken by a public servant? It is to be relatable to.
No, in this case, relatable
Yes.
is quite debatable. We'll see.
Exactly,
Yes.
my lord. Relatable is debatable, my lord. I bow down. That is why an inquiry.
Yes.
My lord, if it was...
That is why an inquiry will see.
that's my submission, my lord.
Relatable is debatable.
Relatable is debate. That's right, my lord. I mean, at the stage of 17A, application of mind, there is no material which is available which can point in one or the other direction. It is a matter where suspicion, needle of suspicion.
No. Needle of suspicion pointing at a particular act of a particular person.
Quite right.
See, needle of suspicion also cannot be in thin air. So there should be something. And he has threadbare told what is there. We'll see whether it is relatable or not.
Quite right. Now, my lord, another important aspect that I want to bring to your lordship notice is relatable. No police officer shall conduct any inquiry or investigation into an offense alleged to have been committed by a public servant under this act. Now, what are the offenses under the provisions of the PCA Act? My lord, kindly see Section 7. My lord, there's something that turns on Section 7, my lord, which I want to point.
Misconduct by a public servant.
No, my lord, there's
So
something more.
this is
There's something more. I want your lordship to be kind enough to see Section 7.
yes.
Any public servant who...
The offense relating to public servant.
Yes, quite. No, my lord.
No, see, 7 is offense relating to public servant being bribed.
No, my lord, kindly see.
The 7C, yes. 7C,
7C.
7C is the only thing that is something there.
Exactly, my lord. 7C, your lordship will kindly see, performs and no, my lord, more importantly is the explanation 1 and explanation 2 to section 7. Performs or induces another public servant to perform improperly or dishonestly a public duty or to forbear performance of such duty in anticipation of, in consequence of accepting an undue advantage from any person. Now, my lord, this is explained by explanation number 1. For the purpose of this section, the obtaining, accepting, or the attempting to obtain an undue advantage shall itself constitute an offense, even if the performance of a public duty by a public servant is not or has not been improper. So, my lord, I ask myself the question, suppose, my lord, in a given case, what has been done is legal. But that legal act has been induced by a public servant.
No, then it does not become an offense.
But then, my lord, I ask myself, what was explanation 1?
legal
Then
act-
kindly see explanation 1.
No, don't, not the self-goal argument.
No, my lord, kindly, no, not in this case. Kindly see explanation 1. Otherwise, explanation 1 will have no meaning. Because for the purpose of this section, obtaining, accepting, or attempting to obtain an undue advantage shall itself constitute an offense, even if the performance of a public duty by a public servant is not, or has not been improper. So let us assume, my lord, in a given case that it is not improper. I'm not in this case, my lord. I'm saying, look at the width of the inquiry that is required to be made under section 17A. It is for that purpose, my lord, that I'm pointing out this. In this case, my lord, I'm going to show to your lordships a few more facts.
2 more facts are there?
Yes, my lord. Yes. I'm going to show to your lordships a few.
More than what he has told.
Yes, my lord. Yes, my lord. There is something more. And on the same facts that my learned friend has placed before your lordships, my lord, I want your lordships to look at it in a manner in which I would like to place it for your lordships.
Different angle.
Different angle, my lord. Therefore, my lord, that would throw some light, would move assistance to your lordships to see as to whether in this case there is something that requires to be investigated or the investigation to be scuttled without anything more. Because if the investigation is scuttled and the governor's order is set aside, there will be nothing more to be done in this case. Unless, my lord, it's a question of re-examination, rewriting, that's a different matter. But
the submissions are otherwise. If you leave that also, everything subsists. Is what he is.
I will, your lordships may look at that also. I'm not saying no. I'm not saying no, my lord. But there are different ways of looking at the same
That's why
issue.
yours is a different angle.
Exactly, my lord. That's why, my lord, when a lawyer, my lord, wanted an adjournment in court on the ground, my lord, that he had forgotten his spectacles. That said, not necessary. Take my spectacles. I'm not going to grant you an adjournment. And the lawyer, my lord, used the judge's spectacles and still said, I want your on an adjournment. He said, why? I'm looking at a case from your point of view. I want to look at it from my point of view. So, my lord, the way, my lord, one learned counsel looks at it, the way your lordship looks at it, the way I look at it are all different. Therefore, my lord, I want to place it from the point of view of how I would look at it. Now, my lord, I have to give a meaning to explanation 1. What is the purpose of saying even if the performance of a public duty by a public servant is not or has not been improper? Now, my lord, suppose, my lord, a legal thing is done in a given case, but it has been induced to be done by a public servant for the purpose of gaining an unfair advantage. Would that amount to an offense under the Act? My lord, explanation 1 seems to suggest that. Otherwise, my lord, these words shall itself constitute an offense even if the performance of a public duty is not or has not been improper. Therefore, my lord, it appears as if the philosophy of the Prevention of Corruption Act is do not use your public office to obtain an advantage.
Legal or illegal.
Exactly. All right. That seems to be the high pedestal of public morality, which, my lord, the Prevention of Corruption Act seeks to protect, my lord. Then, my lord, please look at explanation 2 in the same section, section 7. For the purposes of this section, the expressions obtains or accepts or attempts to obtain shall cover cases where a person being a public servant obtains or accepts or attempts to obtain any undue advantage for himself or for any other person by abusing his position as a public servant or by using his personal influence over another public servant or by any other corrupt or illegal means. So therefore, my lord, even if you have used your personal influence, not necessarily as the boss, not necessarily as the boss, even if you have used your personal influence, it comes within the mischief of section 7. My lord, in a given case, my lord, let's assume a public servant, a minister, my lord, is not in charge of the department. He has nothing, no role to play, but uses his personal influence. My lord, would it constitute a offense under section 7? Explanation 3, explanation 2 seems to suggest yes, it is. The moment you hold a public office, it carries with it certain obligations and certain do's and don'ts which are not attached to a non-public office. Therefore, my lord, even if you are not directly connected, but if you have used your personal influence over a particular matter in respect of which a decision has been taken and you are the beneficiary, that itself constitutes an offense under explanation 2 to section 7. Therefore, my lord, the contours of a offense in respect of which an inquiry is required to be held under section 17A are very wide. That's the point I'm trying to make for your lordship's consideration. Lord, it is not like a complaint which requires ingredients of the offense to be mentioned in the complaint, without which your lordships day in and day out interfere under 482 and quash it.
That's after registration of the crime.
My lord, it is after registration of the crime at the stage of investigation. Yes, but it could be, my lord, it never reached the court, excepting on FIR. Now, in a situation of that kind, even if there is, in the instant case, there are no allegations in the complaint, there's nothing. Still, if the sanctioning authority in the instant case being the Honorable Governor says, well, there is something that requires to be inquired into, not necessarily, my lord, as a list between A versus B, because the philosophy of 17A is different. The whole philosophy of the PCA Act is different. The philosophy, my lord, is to have a purity in public administration. That, my lord, is the paramount object of the Prevention of Corruption Act. If from that point of view, the sanctioning authority says, well, it is as important to be clean as it is to for the people to have confidence in a clean administration. Now, please look at it from that point of view, my lord. It's really not in the nature of a list between the petitioner and anybody else. It is in the interest of purity of public administration. If in that anxiety, if the sanctioning authority says, having regard to the high position that a person is holding, it is necessary that it should be inquired into, I ask myself, what is the scope of interference in a 226 judicial review proceedings? That, my lord, would be the approach I would suggest to your lordships to adopt in this case. It is really not a list between A versus B. There is an element of public interest, and if in that anxiety, the high functionary like the governor, and I will point out your lordship the judgment, my lord, which of course your lordships will be aware of it, that where a discretion is vested with a high functionary, the courts would be very reluctant to interfere with that order. My lord, your lordships are not going to look at, I would respectfully submit, with the order passed by the governor under 17A, in the same manner in which your lordship will look at an order passed by the Tahsildar.
It was submitted.
My lord?
That was argued.
Yes. So therefore, my lord, if it is so, and I'm going to show you some authorities on that. If that is the position, what is the extent to which this court can go into while examining the action of the governor acting under 17A being a constitutional functionary? So therefore, my lord, what I would submit to your lordship is, please look at it from the point of view, not as an adversarial litigation. When your lordships are looking at the sanction under 17A, do not look at it as an adversarial litigation. Please look at it from the point of view of ensuring not only there is purity in public administration, but that public confidence in administration is not sullied. If it is damaged, it is restored. What is the best way of restoring, my lord, an eroded public confidence in administration?
Where is it eroded?
Well, let me develop it, but I will show to your lordships that. What is the best? Because it is the very fact that a commission of inquiry has been constituted under the Commissions of Inquiry Act itself indicates that there is an anxiety to get this matter inquired into because it is a matter of public importance. And that has been referred to by the Honorable Governor in the order. If it was a matter in respect of which no inquiry was required to be done, I asked myself, why was the Commission of Inquiry required? Whole object of the Commission of Inquiry Act is that you will have this inquired into in accordance with the special statute. In order, my lord, your lordship knows, my lord, that the report of the
So
Commission
you are
of
satisfied with the Commission of Inquiry?
No. I
What is your
tell you
suggestion?
lordships why. I tell you lordships why. Commission of Inquiry Act, unfortunately, my lord, a report of a Commission of Inquiry has no teeth.
We'll give it.
My lord, but the statute doesn't, my lord. The statute doesn't, my lord. In fact, there's a recommendation made by the Supreme Court saying that something must be done, nothing has been done. And the Supreme Court, my lord, has recognized that all these commissions of inquiry report are put in cold storage.
We will not permit.
But that is an independent and a parallel remedy. That is not necessarily a bar to a sanction under 17A. Therefore, my lord, this submission I made is in answer to the aspect, my lord, of eroding public confidence in public administration. How is it eroded? The very fact that you constitute a commission of inquiry indicates that there is something to be inquired into. Is it something that does not require, is a matter of public importance, is what the Commission of Inquiry Act
Then there is
says?
something being inquired into.
Yes.
So
Yes.
Why all this exercise?
My lord.
Why all this exercise?
Of course, my lord, there are two parallel remedies. Of course, there are two parallel remedies.
Don't emphasize on what is being inquired into.
No, that is only to answer the question, my lord, as to where is the erosion of public confidence. If there was no fear of erosion of public confidence in public administration, then the question of constituting a commission of inquiry would not arise.